Alright guys, welcome back to the channel. Today's video is a real treat, especially for those of you who've been venting in the comments about judges going too easy on sovereign citizens. Well, not today. In this episode, we're flipping the script with 3 no-nonsense judges facing off against 3 clueless defendants, plus a bonus look at some wild security footage. It's a longer ride than usual, so buckle up and let's dive right in.
So this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. I have Salvatore Malaro appearing on behalf of the defendant, and I have Dave McCready appearing on behalf of the prosecutor's office. This is the date and time. I just have the probation. No, this makes sense. Why is this just a violation of probation today?
Yeah, Judge, I just noticed that myself. We had prelim back in April that got bound upstairs. The transcript's probably due next week, I think, like middle of July, at which point we would be looking at motions to file.
So why don't we move this over to the September 4 date? Because that, if you get transcripts mid-July, that gives you 6 weeks to do your motions.
Well, I think Mr. McKenzie wants things to move a little faster. Is that correct?
Yeah, very.
Well, it takes
trial on 180 days. I even have a prelim for 90 some days. I'm trying to argue that.
So you're waiting on your transcripts, correct?
Yeah.
So they come when they come. They have a time period that they're allowed to get those done by, and they're not going to be done till July. And so you really, your attorneys probably advised you that you don't want to proceed to get those transcripts.
So in order to file a motion for my prelim being pushed back 3 separate times due to the prosecutor filing bad writs or however, I think I just would always.
Well, I can't argue the merits of that today because I got to wait for motions, and your attorney will file the motions.
So that means I can't have a trial in 180 days. That's correct.
Do you want me to set you for trial now?
Yes.
Your Honor.
Without your, yes, Ms. Teskey.
This is a whole separate probation violation from his new crimes. Like, this is a probation violation for him being terminated from treatment. It has nothing to do with his new crimes.
So the only thing we're here for today is your probation violation. If you want to plead to your probation violation, I'll be more than happy to sentence you on that. On your probation violation, you're actually facing up to, let's see. So in your probation violation, it alleges that you absconded from the Eaton County RAP program. And that requires, is that right, Ms. Teskey?
No, he was terminated from the RAP program.
Right. So that's an automatic prison term. Is that correct, Ms. Teskey?
That is correct.
The Wayne County Resident Alternative to Prison, or RAT program, is designed as a second chance option for probation violators who would otherwise be headed to prison. By failing to complete this program, he's basically signing up for a prison sentence, without even factoring in the new charges he's now facing. So the only thing I can do for you today, Mr. McKenzie, because we're only here on the violation of probation, your violation of probation has nothing to do with your new charges. So if you want to plead to your violation of probation from being terminated for getting into a dispute with another inmate in the program, I'd be more than happy to take your plea, but understand you automatically have to go to prison on this.
Judge, when I spoke to Mr. McKenzie about that, he indicated he wanted a separate hearing.
All right, I can set you a trial on this.
Yeah.
So, Ms. Teskey, how long do you need for a trial to get your witnesses from Eaton County on this?
Your Honor, I would say 2 weeks.
2 weeks. All right, Miss Adams, I need probably an hour for a violation of probation trial.
And Your Honor, for the record, I'm sure Mr. McKenzie would oppose any testimony by Zoom.
Oh.
Is that correct, Mr. McKenzie? Yes.
Okay.
Can he do that, Your Honor?
Yep. So, I mean, yeah, it's just someone that works there. That's all you need is someone that works there, right? So, all right. So, Miss Adams, I'm looking for about an hour.
Yeah.
Or are you going to call this?
I'll bring the book in, Judge. I'm not finding an hour.
Okay. And Mr. Malaro, your client would testify potentially. And then who else will you be calling as a witness?
and discuss that with him. Do you have some witnesses?
Yeah, her name's Tamia Dillard.
Oh, she runs the program.
Tamia?
Yeah.
Tamia Dillard, was he there?
No, she's a lady that runs it. They never took a statement or nothing from me.
Well, they don't have to. They don't have to.
Well, Judge, I've spoken to her in the past. I think she runs the program.
All right.
She does,
So,
and she was who I would be calling for a witness as well.
okay. Okay.
Are
So,
you definitely going to call her, Ms. Teskey?
Yes,
So I would not have to subpoena her then?
no,
All right. You okay with that?
Yeah.
All right.
Ms. Anton, could I speak for a second?
no, I'm looking for a date. So you got to wait a minute.
I don't know what the fuck to say.
I'm sorry. What'd you say?
I told him I know what to say. He can't be my lawyer. I can't do this with
Then
him.
you are more than welcome to hire an attorney, but
I need somebody that's gonna do something.
so Mr. McKenzie, here's the deal. You ask for court-appointed attorney, you get a court-appointed
I got
attorney.
this back
Listen
off.
to me. All right, you are held in contempt.
my God.
So I'll bring you back next week. Thank you.
Give me 2 years of contempt, please. Could you?
You're actually looking at 5 years.
Oh, please don't.
Oh, have a good day. Oh, like that's the worst thing I've ever been called. I've been called by,
That's the worst thing you've ever done.
no.
And just like that, one down. And one tough as nails judge who doesn't flinch when a defendant tries to insult them, especially someone who's looking at several years behind bars. Now, let's shift gears to the second hearing in Barnett County Circuit Court, where our next defendant is facing a sticky situation. Let's break down exactly what's going on and whether there's any way out for them.
Mr. Lamprecht, you're pleading guilty to OWI third, is that correct?
Yes,
Those sunglasses, or are they prescription?
prescription.
Do you see the plea questionnaire waiver of rights form I have in front of me?
I see on this,
Did your attorney go over this document with you?
very briefly.
Well, maybe if you weren't 18 minutes late, you could add more time with your attorney, right?
I forgot my money. I had to turn around.
Maybe you should have been here maybe 20 minutes prior to your hearing to go over this with your attorney, correct?
Correct.
And I do have a copy of it in front of them as well.
Thank you. And the fact that you forgot the money, is it the court's problem?
A little bit. I mean, but
Oh, I forgot it for you?
No, it's my problem, but it made it your problem.
It did make it
By
my problem. It made
postponing-
it the district attorney's
by
problem. It made it
postponing-
Mr. Keene's problem.
I apologize.
You are putting my calendar behind right away in the morning.
That's what why I said it is a little bit your problem.
No, it is my problem
Yeah.
because you made it my, he went over this document with you, correct?
I have to do stuff, and I have a copy.
Yeah. Yep. So he's went over multiple times. You've had Mr. Keene for some time on this case, correct?
Mhm.
Yes?
Yes.
And you've had him for this time when you've been trying to complete the IDIP, correct?
Then I have.
Okay. And so, Mr. Keene, this isn't the first time he's talked to you about what it means to plead guilty to an OWI third, correct?
Correct.
And he's went over with you what the state would have to prove, correct?
Yeah.
Correct?
Correct.
And he's went over the maximum penalties and the minimum penalties you could face. Is that correct?
Yeah.
And he's went over the offer with you that has been presented by Mr. Renicky to recommend to the court IDIP guidelines, correct? What the
Yeah.
offer is, correct? Because you know you're doing an IDIP program for benefits, right?
There was a little confusion between my IDIP worker and him about the hours for community
I don't
service.
care about the community
Okay,
service
okay,
hours.
okay. I'm just saying that
The other stuff, right?
the other stuff, yes.
Okay. And so he's went over certain other things with you, right? Such as your constitutional rights. Did he go over that with you?
Yes.
And did he go over the fact that I don't have to accept the IDIP guidelines if I thought that the facts of the case warranted it, or your history, et cetera? Did he go over that with you?
Yes, ma'am.
Okay. So it sounds like he did go over all of the information on this plea questionnaire. Is that your signature on the second page?
Yes.
So you are 44 years old. You can read, write, you understand the English language. You have not had any drugs, alcohol, or other medications, and you have not been deemed mentally incompetent, correct?
Correct.
So do you understand all of those constitutional rights on that document that's sitting there right in front of you?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty, you're waiving and giving up those rights? You won't be able to have those rights again. You can't plead guilty and say, you know what, Judge, I changed my mind. I want a jury trial. You know, do you understand that?
Yes.
And so by pleading guilty, those rights are going away. You understand that?
Yes.
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation? I don't allow coffee in here.
I'm sorry.
I only allow water.
Apologize.
Okay. So do you understand that by pleading guilty, you could be deported if you're not a citizen? I have to ask that
Yes,
to everybody. Okay. And do you understand that, again, here, the state would have to prove certain things, that on or around May 28th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, and this would be a third offense. Do you understand what the state would have to prove?
What would they have to prove?
You operated a motor vehicle.
Okay,
You
yeah,
drove, you operated, you
Yeah.
turned a key, you had the keys
Okay.
in the ignition, you did something to operate the motor vehicle,
Okay.
and that you were under the influence of an intoxicant. You understand that?
Okay.
Okay. Do you understand they would have to prove that?
hmm
Okay. And this is your third offense, third conviction, right? Is that a yes?
Yes.
Okay. And do you understand that upon conviction, you face a fine of not more than $2,000, that excludes court costs and fees, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
Yes.
Plus that the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA, OWI assessment and driver safety plan and follow through. You understand that? Yes?
Yes.
And you should have done that with the IDIP program, so that should be,
It's taken
Covered.
care of.
yes. All right. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
Sorry.
And that's all kinds of fun today.
Damn it.
It's almost comical. She just finished telling him that if she thought the sentence wasn't enough, she could tack on more time. And what happens next? His phone goes off. After all that, he's still managing to make the wrong moves.
Okay.
Sorry about that.
All right. So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one.
Is a question right now going through the plea, or is that a question later for sentencing?
It's just kind of a math question. I just want to know if it's fictional or a fact.
Math is usually not fiction. Why,
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
You want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not, because quite honestly, we go to law school, so we don't have to do math, but we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
I think it's great. The issue, and it's been up, I'm with, Ms. Anderson, he had a question about the grams per 100 milliliters,
Dude,
And
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above the limit.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah,
maybe it's wrong. I don't know.
yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
We can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Finally, the first smart thing he said all day, because the judge is absolutely right. She's trying to hint, without spelling it out, that he doesn't really have a case. And if this ends up going to trial, he could be looking at a whole lot more time behind bars.
I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So, now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce.
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay.
apologize.
You're not supposed to be late to court. Okay. You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating.
No, I'm just
Science.
saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a tenth, 2 numerals behind the decimal is a hundredth.
Yep.
3 numerals behind the decimal is 1,000th.
Yep. I know math.
Okay, and 1,000th is 10 times less than 100th.
No kidding, Sherlock. It doesn't matter if your dumb was measured in hundreds or thousands. If you were over the limit, you were over the limit. At this point, it looks less like a plea and more like you're trying to mount a defense.
Well, let's cut that off. Okay. You blew a .22 with a PBT.
221.
Or .221. Okay. So let's say you will cut off the 1 because that's what math does. You get to cut off certain things. So you were .22. We'll give you the benefit of the doubt. No more with that 1, that 1,000th gone. So you blew a .22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000 is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
But no, if there's three numerals, because if it was point,
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keen? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra 1,000th in the decimal point?
It's not an extra 1,000th though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just so give me the knowledge because I like math.
Clearly, math isn't your friend.
Here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to
hours.
piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and gave me extensions. You're fair. And I'm here. And I'll go to jail. Get out. I got a job. And
all right. So, are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And do you agree that you operated or drove a motor vehicle while in that state?
I agree to that, yes.
All right. Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has they promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten to hurt you or anything?
None of those.
Okay. Are you pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a 0.221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily.
Yes.
Does anyone or are you satisfied with your attorney's services?
I guess 5 out of 10.
You're going to strain something trying to do any more math. And did it ever cross your mind that maybe that 5 out of 10 performance from your attorney was actually a 9 out of 10 caused by your own behavior?